Hello, everyone. Uh, First of all, let me congratulate each one of you who have appeared for today's patent agent examination for year 2023. It was definitely a tough paper if we compare it with regard to the past year question papers. In this video, I have attempted to provide you all with the answers to paper 1. And I'm sure that, like in past, Patent Office will come up with the final set of answer keys in few days from now. Meanwhile, I thought of supporting you all and helping you with the correct set of answers that I feel should be the right choices so that you can identify how you fared well in your paper 1. After this video, there will be another video uploaded for suggestive answers to paper 2, and then you can check as to if you've written it in the similar format or identify with a similar content or not. Please do leave your valuable comments and also do share it widely with your peers and friends so that they also get benefited. Also, you may like to subscribe so that you can get immediate notifications with regard to the upcoming videos on this topic of patent agent examination. So let's get started. So it's about paper 1, year 2023. It's set code B that I'm going to discuss with you. And others who got set code A, B, or D can also match their answers from this video because the question remains the same. It's only that the questions are shuffled in different sets. So part A, it had only one option correct, and it was 2 marks each. So first question was about Sagar, who is an applicant of an invention, who drafted a specification himself and filed the patent application and asked his advice, and he asked his advocate, who is not a patent agent, to appear for the hearing. Question is it allowed according to the Patents Act or not? The correct option looks C from the list of 4. So Sagar can draft the patent specification by himself, and an advocate is allowed to attend the hearing. Second question about the student of one of the institutes, Ashavri Institute of Technology, who invented a new stabilizer and designed a particular shape to make it attractive. They have given a name of the stabilizer as Passion, and further they made an operating manual for the operation of stabilizer. They need IPR protection for the entire stabilizer. And then there are match the followings that one has to do. So the correct answer is B. So for stabilizer, a patent can be filed. So 1C. And then for the shape, design can be filed. So 1D. Sorry, 2D here. So 1C, 2D. And then the trademark can be filed for the name, which is 3B. And then 4A, which is manual, operating manual, which is nothing but a literature and can be protected under copyright. So B is the correct answer for question number 2. Next is Miss Manisha wishes to file a patent application in India, but she came to know that some of the inventions are not patentable in accordance with the Indian Patents Act. Could you please help her to match the list 1 and 2 and select the correct code? And for this, answer number 3, correct option is B. So 1C, which is method of cultivating rose flower, which is covered in section 3H of the Patents Act, which is about the method of horticulture or agriculture. Option 2 is about method of treating brain tumor, which is covered in section 3I. So option 2D is correct for that. Third option is bucket fitted with torch is a mere rearrangement or arrangement. So section 3F is applicable. Hence option 3B is correct. Then fourth option is sugar. And so this question. Next question is question number 5, which is Print Inc. is a large corporation having a sizable portfolio of patents for a single product. So it's like one single product in which multiple patents are being utilized. The technology is being utilized, which is by Print Inc. The product is very popular in Indian market and some of the patents have been licensed to other companies too. Choose the correct option regarding Form 27. So Form 27 is about the working statement under section 146. And the correct option for this is option B as the correct answer for question number 5. So Print Inc. can file a single Form 27 for multiple patents that are related to the said product. So as a testimony, whether this option is correct or not, you may look at Form 27. If you look at Form 27 per se, para number 1, and you read the explanation there, it clarifies that it clearly mentions that Form 27 can be filed for multiple patents or portfolio of patents that are related to each other, and one doesn't therefore have to file separate Form 27 for each of such patents. So correct answer for question number 5 is B. Question number 6 is your client being a MNC filed a patent application and paid all the fees applicable. Your client later on becomes uninterested in the patent application and wishes to seek refund. Please select the option available to your client. So in this, the correct option is C, which is your client can make a request for withdrawal of the patent application before the issuance of first statement of objection and claim a refund up to the tune of 90% of fee paid for request for examination. And for this, you might look at Rule 7.4 and Rule 7.4a, which clarifies about this particular percentage that can be refunded. Question number 7, which is about an inventor who is living in Shimla, Himachal Pradesh, wants to file his patent application along with the demand draft for the amount of fee payable. Please select the correct option available to the inventor. So the correct option here will be that the inventor may send his application by speed post. And the reference for this answer is Rule 7.2a. So you can check that whenever money is to be paid by demand draft, then it has to be sent through speed post, not through the courier. 8. A patent was granted within 1 year from the date of filing of patent application. The patentee will have to pay the renewal fee without taking any extension. And there are 4 options given, out of which option A is correct, which means the renewal fee is to be paid before the expiration of 2nd year from the date of patent in respect of 3rd year. And the reference rules or sections are section 53, subsection 2 and section 142. And also look at schedule 1 of the Patents Act. So question 9, answer option number A is the correct 10. Question number 11, Nilesh filed a patent application on 24th March 2019, upon which a patent was granted. The fact of the grant of patent was published in the official journal on 3rd Jan 2022. Nilesh develops a further improvement of the said invention. Upon conducting a patent and non-patent literature search, Nilesh finds out that the improvement is novel as compared to his own patent. However, the improvement was disclosed in someone else's patent application, which was published on 23rd Jan 2022. Nilesh is in position to file the patent application for patent of addition on 4th Jan 2023. What should Nilesh do? So it's about the improvement, which is already anticipated in someone else's patent application. So in that case, option B is the correct option, that Nilesh should not file a patent application for patent of addition, as his application would be devoid of novelty because it is already there, disclosed in someone else's patent literature. Just give me a moment. Let me just check if YouTube is correctly recording this. Okay, let's go ahead. Question number 12, a post-grant opposition is filed against the patent owned by the company Shelf Life Private Limited. The patentee does not desire to contest opposition or leave his reply and evidence within the prescribed time limit. The patent shall be, whether it will be abandoned, withdrawn, revoked or terminated. So correct answer is B. Please see Rule 58(2) of the Patents Act, and you will find exactly that if the patent applicant or the patentee is not responding, then the application is deemed revoked. The patent is deemed revoked. It's a issue of post-grant opposition, so patent is already granted here. Another question 13, your client Pat Bio wishes to file a patent application in Indian Patent Office for an invention which uses a biological material from India. Arrange the following steps for protection of said invention in most likely chronological order. So the correct answer seems answer number B or option B, which is if a person applies for a patent, permission of National Biodiversity Authority may be obtained after the acceptance of the patent, but before the sealing of the patent. In order to see this, you can look at para 1, page 2 of the guidelines which have been published by the Patent Office. This is the link, and I'll post this link in the video description also. So you can open the link from that video description. So which means if B is the correct option, so as a result, number 1, there has to be first deposit of biological material in the recognized depository authority so that the applicant gets the reference number, then file a patent application. After that, have it published. Thereafter, submit permission from the National Biodiversity Authority and then grant of the patent. So the correct sequence will be 2, 1, 4, 3, 5. Option number B, therefore, is correct answer for question number 13. Next question, question 14. Patent application filed by Rajesh is refused by the controller and said decision communicated on 2nd May 2023. Rajesh can file an application for review of the controller's decision by. The correct answer is, and there are 4 dates as an option given. The correct date will be option number listed in option number B, which is 1st June 2023. Why? Because when you see Rule 130, Section 77, in Form 24, this request for review of the controller's decision can be filed, which mentions that review petition can be filed within 1 month from the date of decision of the controller. This option B, therefore, is correct. Incorrect options are option number 1 because it says 3 months. Third option is also incorrect because it says 6 months, and fourth option is definitely not correct because it is showing 1 year delay time. Question number 15, number of members in the opposition board is, correct answer is 3, including the chairman. And this question is definitely not is a no-brainer. As you can see in Rule 56 also, it clearly says including chairman, total number of members should be 3, including chairman. James, a citizen of Norway. This is question number 16. There are 4 options, whether he can file a patent application directly in India being a citizen of Norway, or can he file a patent application in India only after filing the same in Norway? Can he file a patent application in India only through PCT route, or can file an application only in Norway and not in India? So D is definitely not a correct option. C is also not, because PCT route is not the only mandatory route to file in foreign nations. The only tug of war is between option A or option B. Can he file it directly in India, or can he file it only after having filed in Norway? So we don't know as in what is the status of Norway's Patent Act. So the best bet here is option A. He can file a patent application directly in India, even being a citizen of Norway. But let us wait for the patent office to publish the answer set and we can check. Now, question number 17 is George Sebastian is a US citizen residing at Bangalore and working at a multinational company having offices throughout the world. As a part of research team, George invented a mosquito repellent. However, as per the company policy, the application for patent should be first filed at USPTO. George approached you for getting the advice as to whether he has to do any formalities with the Indian Patent Office. So certainly Section 39 comes into play, which clearly says that any Indian resident, Section 39 doesn't talk about the citizenship. It only talks about the residentship. So any Indian resident first has to file a patent application in India or seek a permission from the patent office before filing abroad. So correct option is B. As George is residing in Bangalore, he has to obtain permission from Indian Patent Office to first file application in US. Question number 18. 3 applicants applied for a patent and patent was granted to them. Which of the following is true? Note that there is no specific contract between them. So if there is no specific contract to the contrary, then automatically Section 50 and 51, which is about the rights of the co-owners, clarifies that all are having equal and undivided share in the patent. So option A is the correct option for question number 18. Question 19. Sorry, I was about to say section 19, but it's question 19. Mr. Suresh has 2 inventions related to tabletop grinder. He filed patents for both inventions in the Indian Patent Office. Patent was granted for one invention and the other was pending. Mr. Suresh assigned all his rights in both the cases to Mr. Birdfly Industries. MS Birdfly Industries, Messrs, not Mr. Mr. Okay. So now which forms are required? So there are several options given, 4 options. So correct option is option B, which is form 16 and form 6. Why? Because if you see section 20, form 6 is to be filed in case of assignment or agreement. A request can be made before the grant of the patent with regard to the addition of name of the new assignee or the proprietor. Similarly, under section 69, form 16 has to be filed about the recordation of such agreement or assignment at the patent office register. So option B is correct for question number 19. Question number 20, an application for patent is open to public just after, and there are 4 options. Is it open to public just after the application is filed, or after the publication of the application, or just after filing of pre-grant opposition? And the last option is just after first examination report is issued in the application. So correct answer is B, which is it is available to public for after the publication of the application. Question number 21. Mohan went to London where he found a bicycle which works without chain. He realized that bicycle is not available in India and wishes to import this bicycle to India and file a patent for it. He approaches for your advice as per the Patent Act 1970. So certainly Mohan is not the true and first inventor, so he cannot be considered a right individual for filing a patent application. Hence option D is correct for question number 21. Question 22, Style and Company, a US company, was granted a patent for a sewing machine in US. Joe is an entrepreneur engaged in manufacture and distribution of sewing machines in India. Joe came to know that Style and Company has not filed a patent application in India. In that case, what will happen? So the correct option is C. Joe can freely manufacture the invention and sell it in India. Why? Because there is no patent in India, hence its use is permissible, as there is no patent rights existing in this country for Style and Company, and patent rights are territorial in nature, and hence Joe is completely free to, however he may wish, he can use that invention. Question number 23, Medley invents a food processor that can chop vegetables and knead flour. Since the work was not complete, she filed for first provisional patent application on a certain date, which is 20th Jan 2022. She filed complete spec thereafter on 15th 4 2022, which is just in the span of 3 months. Later, she invented a fruit juicer unit that can be connected to the food processor. She applied for a patent of addition for the fruit juicer on 15th March 2023. Assuming that both the patents will be granted, the patent term will expire on. So as you have read, even during the classes of patent agent exam training that I undertake, we've done it several times. Section 54 very clearly says that the main patent and patent of addition both expire on the same day. So 20 years will be counted from the first filing, which is from 20th January 2022. So option A is correct. So the final day on which both the patents shall expire shall be 20th Jan 2042. Question number 24, Gopal has filed a patent application along with necessary fee, but the application was not published. What could be the reasons? Option is D, which is Gopal filed only provisional specification. And like again, we've studied in our training classes, provisional application is not published unless it is also supplemented by the complete spec. It's the complete spec that is published. So D is the correct option for question 24. Question 25, Gautam made a model of speedboat, which he invented. He files for a patent for the speedboat. Which of the following statement is correct? And this is regarding the model. The model has to be given to the patent office or not. Does it become part of the complete spec or not? So section 10.3 is the relevant section for it, and the correct option is C. So section 3 very clearly says that if in any particular case controller considers that an application should be further supplemented by a model or sample of anything illustrating the invention or alleged to constitute an invention, such model or sample as he may require shall be furnished before the application is found in order of grant. But such model or sample shall not be deemed to form the part of the spec. Hence, C is the correct option. Model is not part of this complete specification, but has to be furnished if required by the controller. Question 26. So there are a total of 50 questions. We are almost midway. Another 25 left. So let's do it quickly. Question number 26. Shiva was a great inventor for solar batteries, and he filed 5 patent applications. Though the patent were granted for all the 5 inventions, Shiva died before the date of the grant of patents due to sudden cardiac arrest. Shiva's only son, Gana, approached you for advice. What section will be applicable? So section 4 is applicable, certainly, because it is about the amendment of the patent granted to a deceased applicant. Okay. Question number 27. Raju Gomez, a US citizen, filed 2 patent applications with US PTO. He filed a convention patent application. So he filed application in US on 28/4/2017. He filed a convention application in India on 27/4/2018, claiming priority from one of the US application. He filed a PCT international application then on 25th April 2018, claiming priority from the other application, and entered PCT national phase in India on 31st March 2019. The date of the patent for convention application and the national phase application are respectively. So there are 4 options. Option A is correct. See section 53, its explanation part. So when it comes to PCT, it is the PCT filing date which becomes the date of patent. And in case of convention patent application, even if it takes the priority from a foreign patent, the 20 years term period will be calculated. The date of the patent shall be the date on which convention application was filed. Convention was filed on 27/4/2008, which is listed in option A, and the PCT filing date is 25/4/2018, which is also listed in option A. So A is the correct option for question 27. Let me just once again do a quick check on YouTube recording. Okay. 28th question number. Your client who filed a PCT international application received the international search report from International Searching Authority. In the search report, category code X is mentioned against a prior art document. Category code X means what in this PCT application? So if you have looked at the PCT application, you go to the last page, there is search report that is attached as along with the patent application. In that, whenever the searching authority does a prior art search, they categorize prior art references in different categories. They bucket it into different categories. So when it is written patent references under category code X, it means it is either not novel or not inventive. So option C is the correct option for question number 28. So question number 29. Dr. Karan got a patent for surgical equipment. Dr. Vimla used that patented surgical equipment for research purpose. Dr. Karan issued a legal notice to Dr. Vimla for infringement. Dr. Vimla approached for your guidance. Which one is following out of the following is correct? So in this, option A is correct. Because if you read section 47 subsection 3, it allows for the fair use of the patented invention for research purposes. So Dr. Vimla can use it freely for research. Question number 13. Lemira is a startup in the field of space engineering. They have filed for patents and wish to get them granted at the earliest, so that they can carry out their business. So which of the following 4 options is correct? Option A is correct, which is Lemira should file request for early publication and request for expedited examination because they want to get it granted at the earliest. So A is correct. Now we come to part B of this question paper, paper 1 of the examination. This is for 10 marks, so total of 10 questions, 1 mark each for each question. And there are, you need to choose it from A, B, C or D, basis whichever statement is correct and which is not correct. And if whether both are false or both are true. So question number 31, first statement is time for putting an application in order of grant under section 21 shall be 6 months from the date of first statement of objection issued to the applicant, which is correct option. option number 2 is not correct. So option A is correct. Hence, the correct option is answer for question number 31 is A. Because second is not correct. It says time for putting an application in order of grant can be further extended by 6 months. It cannot be extended by 3 months. It's only extendable by 3 months and not by 6 months. Question number 32. Company X is having place of business at US and filed initial application at US PTO, and after 6 months from the US application, the company has done some modifications and filed a patent application for the same at Japan. Within 12 months from the date of US filing, Company X filed an Indian patent application claiming priority of earlier 2 applications from US and Japan. So which one is the correct option? So option B is correct, A is not. So Company X is allowed to claim both the priorities because one claimed an invention, the main invention, and the other one claimed a modification. So it was a new subject matter. So both the priorities will be applicable. Question number 33. The term of every patent starts from the date of filing of patent application. Is this correct? Yes, it is. Whether option 2 is correct, which is no suit or other proceedings shall be commenced or prosecuted in respect of an infringement committed before the date of publication of the application. So the correct option is D, which is both the options are correct. 35th question. Question 36. The claim lacks inventive step due to prior art disclosure in a single document combined with the common general knowledge. So this is absolutely a correct option. And also the second option seems correct. The claim lacks inventive step due to combination of prior art. So it's a mosaicing of the multiple prior art references. So both seems correct. So inventive step is generally checked through mosaicing of prior art references, and also common general knowledge is equally important. So D for question number 36. Question 37. In a case where an application processed by a startup is partly transferred to a multinational company, then what happens? There are two options. The first option seems incorrect because it says the new application is not required to pay a difference in the scale of fees if it is transferred to multinational. Because if you look at Rule 7.3, a differential of fee is to be paid by the new applicant, which is multinational here. And option 2 is correct. So the new applicant shall file a request for the change in the name of the applicant also, because it is partly transferred. The rights are partly transferred to the MNC. So answer should be B for question number 37, which is first option incorrect and second option correct. Let's look at part C, which is the last part of paper 1. It is of 30 marks and there are 10 multiple choice questions of 3 marks each, which has more than one option correct. At least 2 options are correct. It could be even more. So if you know the marking scheme, if you do not choose all the options correct, let's say you choose one additional option which is not correct, you get 0 marks. And if you choose one option less out of the total correct list of choices, then also you get a wrong marking, 0 marking. So let's go with question 38. While doing amendments in the specification, an applicant shall provide a marked copy clearly identifying the amendments carried out. And second is applicant shall provide a statement clearly indicating the portion of the specification or drawing being amended along with the reasons that shall be filled in. Just a second, I think I should have not pasted it here, but so we are still going ahead with the previous part B of the paper only, and part C is yet to start. Okay, so so here 38 option D is correct. Both options are correct. Both the listed statements are correct. Question 39. An application for patent is refused by the controller. The applicant wishes to challenge the refusal. And there are 2 options: whether applicant can approach IPAB, like you know, appellate board is no more there, it has been dissolved already, and any of the decisions of the controller have now to go straight to the court, High Court, which is mentioned in section 117A. So option C is correct. So which means both the options listed are false. So C. Question number 40. A legal representative means a person who in law represents the estate of a deceased person, which is correct option. So option 1 is correct. Option 2, legal representative means a person who files an application on behalf of the applicant, which is incorrect. So A should be chosen. This first option correct and second incorrect. Now it's part C, which is about 30 marks, 10 multiple choice questions, 3 marks each. So minimum 2 options are correct, and there could be more than 2 options correct. So if you choose one extra, okay, then also you get 0 marks. If you choose one less or one missing is there, or you choose an incorrect one while rest of the choices may be correct, still you get 0 marks. So let us see what is the correct option for question number 41. Rajesh, a patent agent who is registered with patent office, may get disqualified on the following grounds. On all the four following grounds, he can be disqualified. A, B, C, D. 4 options are correct. See rule 114 to ensure to cross-verify or this answer as correct. Mr. Ujwal, this is question number 42. He would like to know time limits generally available for extension of time using Form 4 in accordance with the patent law. So in this first option is certainly not correct. The answer to question number 42 is B, C, D. Option A is not correct. See rule 13.6, which says timelines has to be 1 month to file Form 5, which is declaration of inventorship. Option B is correct. It's listed in rule 80, which allows extension of 6 months on filing request on Form 4. Option C is again correct. See section 21, rule 24C, sub rule 11, which is time for putting an application in the order of grant can be extended by 3 months after 6 months. So it's 6 plus 3 total. And option D is correct, as the timeline is listed in section 77, rule 130, form 25, which is 1 month extension you get additional to file a review petition to the controller. Question number 43. After receiving the international search report and written opinion of International Search Authority, the applicant may. What all can he do? Can he enter the national phase? Can he submit informal comments to IB? So at least he can enter the national phase. This is very clear as A as a correct option. Now, can he submit informal comments to IB? Seems B is correct as well. Amend claims and file demand for international preliminary examination. Absolutely correct. D, submit reply to international search report and written opinion to ISA. Now, whether this option 4 is correct or not, meaning D option. I don't think it is. Final set of correct answer choices should be A, B, C. And just to cross-verify this answer, I have looked upon the WIPO literature material. It says that written opinion is not published together with the application. So there appears no question of filing a written statement or written opinion on ISA. Plus it says no formal procedure for applicants to respond to written opinion of ISA. So D anyway goes out. And possibility to submit informal comments to IB, which will communicate such comments to DOs together with IPRP. So therefore B is correct. So A, B, C, to the best of my understanding, are the correct choices for question number 43. Question 44, Patent Office has objected novelty based on cited document and issued first statement of objection to you. You can do the following act. So there are 4 choices. Choice A, B, and C seems to be the correct one. D certainly is not correct. I mean, to the best of my understanding, which says you can challenge the objection of novelty in court. You cannot challenge the objection of novelty. You can only challenge the final decision of the controller. Here, it's only the office action issued, and he's just asking the the applicant to give reply. So only after he finally disposes of, you cannot go to the court just like that. So it is still at the patent office level. So ABC seems to be the correct option for question 44. Question 45, term of patent application starts from. So A and D are the correct choices, which is it starts from the date of filing of provisional. And the D is date of filing in India in case of convention application. So whenever convention application is filed in India, that's the correct date. B and C are not the correct options. Question number 46, who are eligible for expedited examination for application? So correct option seems A and D, which is the natural persons where at least one is female, or startup or small entities. Question number 47, which is true about statement and undertaking regarding foreign application. Again, question number 47, A and C seems to be correct, which is statement and undertaking. Statement can be filed within 6 months from the date of filing of application, and the one has to furnish the information about the objections with regard to novelty, patentability within 6 months to the controller. So A and C seems to be the correct option for question 47. 48, Rohan happened to visit Himalaya along with trekking team. While staying there, he wrote a book related to Himalayan mountain ranges, took some videos about a novel and attractive device for easy trekking, and discovered a stone naturally occurring there. He wishes to get patent rights, IP rights on all of them, and he has approached you for filing the application. He can apply or register for, and there are 4 options. So A seems a correct option, which is copyright for book and video he can do. D is also a correct option. He can file a patent and design for the device. B is incorrect option because design for stone he cannot take, because stone is already discovered naturally. It is existing naturally. Anything which is existing naturally, you cannot patent. It's a mere discovery. And therefore B is incorrect. Similarly, C is incorrect, which says he cannot take a design for a device, which is wrong because he has invented an attractive device which is appealing to eyes, let's say. So a design registration can be done. Question number 49, a patent application was filed by company A on 1st Jan 2021 and was published in the Patent Office Journal on 1st July 2022. The first set of objection was raised on 3rd August 2022, and the applicant filed a response complying with all objections on 5th October 2022. So although he has complied with all the objections, but it is not yet granted patent. So unless the patent is granted and published, he cannot file a suit against any other company who may be infringing his patent. So this is what exactly is happening. On 10th October 2022, the applicant noticed that the competitor, company B, is selling a product which utilizes the applicant's invention that was disclosed in the patent application. Choose the correct option. So A and D seems to be the correct option. The company may send a legal notice to company B, and B, which is upon the grant of patent, company A is entitled to seek damages from 1st July 2022, and which is when the application was published. B and C are not the correct choices because infringement suit cannot be filed against a competitor as the publication of grant of patent is must. Here it is, as per the question, it doesn't seem that the patent is granted. It is only the applicant has complied with the objections. Option C is also doesn't seem to be correct because damages are available from the date of publication and not from the date of on which the application was filed. Last question, question number 50. Company X files a patent application which upon examination was objected to on the grounds that the application contains a plurality of distinct inventions. X files a further application in response to the objections raised in the examination report. Choose the correct option. So in this, B and C seems to be the correct option. So the controller may require such amendment of the complete spec filed in pursuance of either original or further application as it may be necessary. And then the last, the C option is also correct. The complete spec of further application should not include any matter not in substance disclosed in the complete spec filed in pursuance of the first mentioned application. So it's the case of divisional patent application basically. So there cannot be new matter. Hence, B and C seems to be the correct. So with this, I must thank you all for listening in. And as you can see, it was well researched. I mean, before presenting this video to you, I had to really go through the Patent Act to make sure that whatever I'm presenting as the right, choices is actually matched with the Patent Act with regard to its relevant forms and sections. So it has taken a lot of effort. And I must also thank all my students because I've been continuously interacting with them, as soon as the paper got over. We were discussing so that we could bring to you this video for benefit to all of you. So at least minimum that I can ask you for, therefore, is to please share it widely so that others also get benefited, and subscribe to the channel as we continue to come up with more videos. Thank you so much. And I'll stop the recording here now.